The breaking news tonight is that the divorce proceedings between Prince Harry, the Duke of Sussex, and Meghan, the Duchess of Sussex, are progressing through the relevant legal channels in both countries in an orderly and cooperative manner. Both parties have confirmed through their respective representatives that they are committed to managing the proceedings in a way that places the welfare of their children above all other considerations. The children, Archie and Lilibet, will divide their time between California and the United Kingdom in an arrangement that is being developed with care and in a spirit of genuine good faith by everyone involved. That is the official account. It has not been disputed by any source close to either party. It appears, from the outside, to be exactly what a contested separation at this level is, sometimes, rarely, and against considerable odds, capable of being. But that is not the part that has everyone talking. The part that has everyone talking is a 43-page document that was filed in the Family Division of the High Court of Justice of England and Wales 14 months before the separation became public. A document that Harry's legal team assembled across more than a year that was reviewed by a senior judge sitting in chambers, sealed under a formal court order, and entered into the record under a reference number that does not appear in any American court file, and that Meghan's legal team, by the account of those who were present when it was first located, had no knowledge of until one of her attorneys encountered an unfamiliar reference number in a routine filing cross-check and ran it through an international litigation database. What came back when that search returned? Its result changed the shape of every legal proceeding that followed. And what was on page 7 of that document changed it further. Let me tell you what actually happened. To understand what Harry's legal team filed and why it carried the weight it carried, and why the document that came back when that reference number was queried was capable of doing what it did to the American proceedings, you need to understand something that is not commonly discussed in coverage of cases of this kind, but that is extremely well understood by every international family law practitioner operating at the senior level in London and Los Angeles. It concerns a legal principle called habitual residence, and it is the principle on which everything in this account turns. Habitual residence is not where a child was born. It is not the location of the primary caregiver. It is not where the nicer house stands, or where the better school is, or where the longer established social life has been built. Habitual residence, under the terms of the Hague Convention on the civil aspects of international child abduction, and under the provisions of Section 3 of the Family Law Act 1986 as it applies in England and Wales, is established by presence, by pattern, by the accumulation of documented time in a jurisdiction over a sufficient period in circumstances that a court can review and formally determine. And once a court in one country has made that determination, it cannot be overridden by a filing made in a different country after the fact by a party who did not participate in the original proceedings, regardless of how persuasive the evidence produced in the second filing might be. The word after is doing significant work in that sentence. After is the condition Harry's legal team had been building toward for 14 months. In the period beginning 14 months before the separation became public, Harry had been increasing the length of his stays in the United Kingdom, not conspicuously, not in a way that was framed or presented or briefed to the press as anything beyond what it appeared to be a member of the royal family visiting his country of birth. Spending time with the institution he had been born into, attending occasions that required his presence in person. The visits attracted the coverage they always attracted, the arrival footage, the drive to Frogmore, the occasional photograph at a public event. None of that coverage focused on duration with any precision. There was no context in which the length of those stays, measured in days and cross-referenced with the children's presence in England during those same periods, would have appeared significant to anyone writing about them at the time. The children came with Harry on some of those trips, not all of them, not on a schedule that would have appeared to follow any deliberate pattern to anyone who was not Harry's legal team. Archie spent 6 weeks in the United Kingdom across the first of those years, then 8 weeks across the year that followed. Then, during a period when Meghan remained in California for professional commitments that were publicly announced and documented, 12 weeks across 3 separate trips, in a calendar year during which the children's mother was not in England for a single day of that time. At no point across those 14 months did Meghan submit any written objection to the children's visits to the United Kingdom. There was no correspondence establishing a limit on the duration of those trips. There was no agreement in any form, on any piece of paper, in any legal file, that California was to be treated as the exclusive or primary legal home jurisdiction for either child. There was no notation anywhere in any exchange between any legal representative from either side that the pattern of time these children were spending in England should not be recorded or should not count toward any subsequent assessment. That absence of any formal objection was not an oversight on Harry's team's part. It was the foundation on which everything else they filed was built. The specific legal weight of that silence is worth pausing on. Under the framework that governs international custody matters between the United States and the United Kingdom, a parent who wishes to establish one country as the exclusive jurisdiction for their children's custody arrangements has a procedural obligation to communicate that intention to the other parent, not as a courtesy, as a requirement. The absence of that communication, the absence of any written record that one parent told the other what they intended and when and through which legal channel is not a neutral fact. It is the specific gap that a habitual residence application in the other jurisdiction can be built around. Harry's legal team had been watching that gap form, month by month, across every trip that passed, without a formal objection. They were not waiting for Meghan to make a mistake. They were documenting the silence that already existed. Meghan's lead attorney was conducting a routine cross-reference of the Consolidated Filing Index for the American divorce proceedings, a procedural task, methodical and unglamorous, the kind of clerical verification that every well-run litigation team performs when assembling the complete picture of what is in the record. When she encountered a reference number that did not correspond to any American court document she had seen, the format was wrong. The prefix used by California courts was absent. She flagged it to a colleague. The colleague ran it through their international litigation database. The result returned within the hour. The reference number belonged to a UK family court filing, England and Wales. The stamped date on the document was 14 months before the separation had appeared in any publication anywhere. She pulled the document. Its formal title was The Children's Jurisdiction and Habitual Residence Determination Consolidated Filing, reference UKFC 2024H AB0391. She read it from the beginning, 43 pages. She read it in the same way that you read something when you were not yet certain what you were reading, but you understand that you cannot stop in the middle because stopping would mean putting down something you are not yet prepared to put down. Formal legal language throughout, every page formatted in the precise administrative style of the family division of the High Court. Numbered exhibits attached at the back, sworn statements in support of the application, a detailed chronology compiled with considerable specificity and cross-referenced across multiple independent sources of every trip that Archie and Lilibet had made to the United Kingdom in the preceding 26 months. That chronology was cross-referenced with school attendance records from the children's time in England, with medical appointment logs from that same period, and with dated photographic evidence from the relevant dates. A summary of applicable UK case law on habitual residence stretching back 20 years, annotated in full and applied directly to the specific documented facts of this matter. A schedule of relevant statutory provisions with explanatory annotation, arguments addressing and dismissing each of the counter-arguments a competent opposing counsel might have raised. And then, beginning on page 31, the determination itself. The Honourable Mr. Justice Whitmore, sitting in the Family Division of the High Court of Justice of England and Wales, had reviewed the documentary evidence presented in full, considered the submissions made by the applicant's legal representatives, and found that the habitual residence of both children had been established in England and Wales to the standard required to warrant a formal court determination under the applicable provisions of UK family law and the relevant articles, the Hague Convention. The determination had been granted, the order had been sealed, the matter, as far as the court was concerned, was closed. That had happened 14 months ago. She read the final clause of the determination. She placed the document on the table in front of her. She sat with it in front of her for 53 minutes before she called the team together. The call lasted 4 hours. There was one thing she did not tell the rest of the team when the call began. There was something on page 7 of the determination in the background section in the third item under the heading Relevant Parental Correspondence that she had read and had not yet fully absorbed. Something she had not yet told anyone because she needed to sit with what it meant before she could explain what had changed. We will come back to page 7 because what was on page 7 is the reason the countermove that followed failed in exactly the way it failed. And it is the reason that 3 senior members of Meghan's original legal team submitted formal requests to be withdrawn from the matter the morning after the hearing in Los Angeles. If you are still watching at that point in this video, you will understand why. Meghan's legal team filed the California Jurisdictional Priority and Parental Domicile Assertion emergency application in the Los Angeles County Superior Court Family Division. The application was thorough. It cited the children's established schooling in California, their settled community life, the continuity of their daily routines and social connections, the depth of their integration into life in Montecito, their proximity to extended family and to friends their own age. It argued that the United Kingdom habitual residence filing had been made unilaterally, without Meghan's knowledge or participation, and that California, where both children had been raised since they were very young, where their primary home stood, where their lived experience had been formed, was the jurisdiction that should take legal precedence for all custody determinations going forward. Accompanying the application was a 7-page sworn declaration from Meghan herself, signed and certified. 7 pages covering in specific and concrete terms the day-to-day care she provided for Archie and Lilibet, the school pickups and drop-offs, the afternoon activities, the medical appointments arranged and attended, the evening routines, the presence she maintained, not as an abstraction, but as the person who had been physically there for the overwhelming majority of their waking hours across every week of their Californian lives. The declaration did not speak in generalities, it spoke in specifics. It was signed. The hearing was set for the following Thursday. Harry's UK solicitor appeared by video link from London. The connection was stable and clear. The room behind him was plain and spare: a desk, a chair, pale walls, a window with daylight coming through from the left. He had a single folder on the desk in front of him, nothing else on the desk. No case card, no second chair beside him, no associate counsel visible in the background. One folder. Meghan's lead attorney presented the primary caregiver case for the court with considerable force and precision. She walked the judge through the school records. She walked through the medical records. She entered the 7-page declaration into the record and summarized its contents for the court in specific detail, point by point. She made the argument about California as the children's settled home with the depth and specificity that reflected the thoroughness of the preparation her team had made in the weeks since filing. She was clear, professional, and complete. When she finished, she sat down. Harry's solicitor did not stand. He sat. He opened the folder. He did not look at his notes. He looked toward the camera, and he asked one question. Can you tell the court the date on which your client formally notified the children's father that she intended to establish California as the children's sole and permanent jurisdiction for the purposes of custody and habitual residence? And can you produce that notification for the court? Meghan's attorney looked at her notes. She looked at co-counsel beside her. She looked at the folder on the table in front of her. There was a pause. By the account of those who were present in the room, it lasted considerably longer than it felt. There was no notification. There had never been a notification. Under the terms of the Hague Convention as applied to international habitual residence proceedings, a unilateral claim by one parent that a jurisdiction other than the one in which a formal determination has been made should take precedence requires, at minimum, documented evidence that the other parent was informed of that intention before the existing determination was sealed, or documented evidence of the other parent's formal refusal, which would trigger its own separate challenge process. Neither existed in any form in any legal file. The California emergency application had been filed after the UK determination had already been sealed and closed. The notification that Harry's solicitor was asking Meghan's attorney to produce before the judge had never been sent, not 14 months ago, not 12 months ago, not at any point in any exchange between any legal representative from either side. The Los Angeles judge asked whether counsel for the applicant had a response. A second pause held the room. The judge ruled from the bench. She ruled that, given the existence of the sealed habitual residence determination made in the UK family court, reference UKFC 2024 HAB 0391, the California Jurisdictional Priority and Parental Domicile Assertion Emergency Application had been filed without the procedural foundation required under the applicable provisions of the Hague Convention. Jurisdiction lay with the UK determination. The emergency application was denied. She said this clearly. Without elaboration, the emergency application was denied. At 11:43 in the morning, Meghan's lead attorney stood on the pavement outside the courthouse for 17 minutes before she got into the car. Now, page 7. Page 7 of the Children's Jurisdiction and Habitual Residence Determination, Consolidated Filing, reference UKFC 2024 HAB 0391, contains a section headed Relevant Parental Correspondence. The section enters into the record the written correspondence between the parties and their legal representatives that bore directly on the question of habitual residence communications relevant to what either parent knew, said, or put in writing about the children's jurisdictional home during the period covered by the filing. Item 3 in that section was a letter, not a letter prepared by a solicitor's office, not a typed document produced on firm letterhead, handwritten, 3 paragraphs, written on plain white paper without any heading, dated 14 months before the hearing in Los Angeles. The letter was written by Harry, in his own hand, addressed to his UK solicitor. The first paragraph noted the pattern of the children's visits to the United Kingdom over the preceding year, their duration, and the documentary record that had accumulated during that period. The second paragraph set out Harry's belief that without a formal legal recognition of the children's connection to England and Wales, that connection to their family in this country, to their heritage, to the country in which their grandfather and great-grandmother had each given their life in service to the institution, would be progressively and perhaps irrecoverably eroded in a way that no subsequent arrangement could fully restore once the erosion had run far enough. The third paragraph instructed his solicitor to initiate habitual residence proceedings for both children in England and Wales at the earliest practical opportunity. The letter was signed by Harry, his full signature, and below the signature, in smaller letters, also written in his hand, a single line, "For the record." And for the children, when they are old enough to read it, the letter had been entered into the UK court record as Exhibit H1. It had been on that file for 14 months. It had been reviewed by Mr. Justice Whitmore when he considered the evidence in support of the habitual residence determination. It had been sealed inside the order that closed the matter. On the morning after the Los Angeles hearing, the third lead attorney, to be assigned to the matter, brought in after the emergency application was denied, and after 3 members of the original team had submitted their withdrawal requests, read page 7 of the determination for the first time. She read the final line of the handwritten letter. She was quiet for a long moment. Those present describe her as sitting very still. Then she turned to page 8. Filed. There is a particular quality to the way Harry's legal team had structured what happened in Los Angeles, and it is worth considering it in detail because it explains why the countermove failed with the completeness it did and why its failure was so difficult to address after the fact. Meghan's team had prepared for a contested hearing. They had assembled materials in anticipation of the challenges they expected. They had expected Harry's solicitor to contest the declaration, to challenge the accuracy of the care records, to question the school documentation, to raise objections to specific aspects of the account of daily life she had set out across 7 pages. They had additional materials ready in response to those expected challenges. They had a witness prepared who could speak to the children's integration into their Californian community. They had prepared, considered, and specific responses to every challenge they believed the other side would make. Harry's solicitor did not make any of those challenges. He did not contest a single line of the 7-page sworn declaration. He did not question the school records. He did not raise any objection to the medical documentation. He did not ask a single question about any piece of evidence Meghan's attorney had placed before the court. He did not challenge any of it because he had not come to challenge it. He had come to ask when Meghan had told Harry what she was planning. That is the difference between a counterargument and a counterposition. A counterargument contests what you placed in the record. A counterposition removes the ground the record is standing on. Harry's solicitor had not come to argue with the 7 pages. He had come to demonstrate that the 7 pages, whatever they contained, could not answer the one question the hearing required her to answer. And the moment the hearing became about the absence of the notification rather than the presence of everything else, the everything else stopped mattering. The absence of a challenge was not a gap in the argument, it was the argument. The moment his solicitor declined to contest the evidence of Meghan's care and the children's settled Californian life, the focus of the proceeding shifted away from what was in the record and toward the one thing that was absent from it, the notification that had never been sent, not the things both sides had placed before the judge, the thing that was missing, the document that had never been produced because it had never existed. Because you cannot challenge what is not there, and what was not there ended the proceeding in 12 minutes. Harry was not in Los Angeles that morning. He was not in the courtroom, he was not on a video link, he did not submit a personal declaration, he did not appear in any form. His name appeared in the proceedings only as the respondent on the original filing. His UK solicitor had spoken 4 sentences in the hearing. His name, his firm, his right of audience in the matter, and then the one question, 4 sentences, against the 7-page declaration, against the school records, against the medical documentation, against everything Meghan's team had assembled and prepared and presented. 4 sentences. When the ruling came from the bench, Harry's solicitor thanked the judge, closed the folder, and ended the video call. The screen on the courtroom display went dark. The room, by the account of those present, held a particular quality of stillness for a moment before anyone moved or spoke. That was the complete extent of the counter-argument. That was all of it. And when you understand what had been built across 14 months to make those 4 sentences sufficient, the stillness in that room makes complete sense. That evening, a statement was issued by Meghan's office. It described the hearing as a procedural development in the ongoing proceedings and emphasized her deep and unbroken commitment to the well-being of her children and to her close and loving relationship with both Archie and Lilibet. Regardless of how the legal proceedings might develop, it noted that her legal team would be exploring all available options going forward. Exploring, that was the word they chose. The UK determination was sealed. The Los Angeles ruling was on the record. Every international family law practitioner who read that statement with an understanding of the context in which it was issued understood what the word exploring carried. It carried the weight of a position that had been significantly narrowed. The 14 months of documented visits, the sworn statements submitted to the UK court, the handwritten letter on Exhibit H1, and the sealed determination of a family division high court judge had together produced something that a post facto emergency application in California, however carefully constructed, had been unable to touch. The ground had shifted. It had shifted quietly across a long period of time, built piece by piece in a way that had not drawn any attention while it was being built, and it had shifted in a direction that a single court filing made after the determination was already sealed could not correct. The door had closed, without any of the drama that a proceeding at this level might have been expected to produce, without raised voices, without contested evidence, without any of the back and forth that these hearings are sometimes capable of generating when both sides arrive with equivalent preparation and equivalent standing. One question, one pause, one ruling from the bench. That was all it had taken. That was all it needed to take, because the architecture of what Harry's legal team had built did not require a hearing to go well. It only required a hearing to happen. By the time Meghan's emergency application was filed, the outcome had already been written into the record 14 months earlier. The hearing in Los Angeles was not where the matter was decided. It was where the decision that had already been made became visible to everyone in the room. 3 senior members of Meghan's original legal team submitted formal requests to be withdrawn from the matter the following morning. Those requests were processed. New lead counsel was retained within the week. In the briefing given to the incoming attorneys, the full briefing covering the UK filing, the emergency application, the hearing, the court record, in its entirety, one item required a separate and specific explanation that went beyond anything else in the briefing. Not the habitual residence determination, not the denied emergency application, not the handwritten letter on page 7 of the filing entered as Exhibit H1, a second document, a document that Harry's UK solicitor had filed on the same date as UK FC 2024 HAB 0391, the same date, the same courthouse under a different reference number. in a different division of the same court. A document that had not surfaced in any cross-reference of any American filing. A document that had not appeared in any disclosure from Harry's team. A document that was, as of the date of the Los Angeles hearing, completely outside the scope of anything Meghan's attorneys had known to look for. It was not a custody filing. It was not a financial application. It was not related to any of the matters currently before either the UK or American courts in the divorce proceedings. The incoming lead attorney found the reference number while reviewing the full court record after her first briefing session. She identified the division. She identified the case category under which the document had been filed. Those present in the room describe her as having looked at the reference number and the division and the case category without speaking for a long moment. And then she looked at the colleague beside her and said that she had not encountered a filing in that category in a case at this level in 11 years of practice. The document is sealed. The reference number appears in the public court record. The division appears alongside it. The case category appears alongside the division. Only the contents are sealed from view. But the case category is not sealed. It is visible to anyone who knows where to look and understands what it signifies. And what that category tells you, if you have spent sufficient time inside these proceedings to understand the institutional weight that category carries, is that the habitual residence determination was not the first move Harry's legal team made across those 14 months. It was not, despite producing the outcome it produced in Los Angeles, the most significant move they made in that courthouse. It was the visible move. The one that Meghan's team would find and examine and attempt to challenge in the American courts, while the second document sat filed and sealed in a different division, present in the record, accessible by reference number, inaccessible to any challenge that did not already know it existed and understand what it contained. The habitual residence determination was what Harry's legal team needed everyone to be looking at. The second document is what was filed while they were looking at it. What is inside it is what determines everything that happens next. Subscribe and hit the notification bell, and make sure you have turned on all notifications, because part 2 drops this week. When it does, the full picture of what Harry's legal team built across 14 months, both documents, both reference numbers, both divisions of the same court, and the sequence in which they were designed to operate together will become clear in a way that changes how you have understood every public statement, every carefully timed appearance, and every precisely worded communication that has come from either side since the day the separation was first announced. The second document is there. The reference number is real. The case category under which it was filed is not a category that any legal team reaches for unless they have thought very carefully about where this is going and have already decided how it ends. And Harry's legal team has thought very carefully about where this is going for a very long time, long enough to file it before anyone was watching. Long enough that by the time anyone was watching, it was already sealed. Part 2 is coming.